tell you, I need to calm all of this down. Every bit. Hey y'all, we waiting for things to get started, but this right here so far is typical of what's going on down here in Fulton County. It's been a hot mess. Judge Glanville need to go ahead and sit down, probably somewhere his feelings because he got about 20 motions to recuse himself from this trial. So he probably trying to pull it together before he come out here and be petty as hell. I wonder if they got that courtroom clean. 'Cause, I was advised that one of the attorneys got that C-19. That might be a problem as well. Hey, y'all need to come on because y'all a whole half hour late. Get this together. Hey, D.
You. How we looking?
It's already started off. It's super late. Make sure these lights is together. You need to be telling me. So far, you're going, we ain't missed nothing. I've been on since been on. Child. I believe you're probably in the back have some kind of temper tantrum. You got to speak to these motions. Y'all got any questions while we wait for them to get started? We can answer for y'all. Might be close to get ready to get some action. It's popping. D, is Lil Woody scheduled to testify today?
What you said?
I said, is Lil Woody scheduled to testify today?
Your audio is a little choppy.
No, I was saying, is Woody scheduled to testify today?
No. Nobody's scheduled to testify till Thursday, I think. Unless something changes. So today I think they're gonna do some motions. Originally, I mean, you know that could change. And tomorrow they're off tomorrow.
They're teasing us with this. Come on, come on.
They haven't adjusted the audio in the court.
motion, Mr. Banks, and on behalf of everyone that is here, I'm going to just take up the issue of the recusal. I'm going to defer the issue of the motion to quash at this point in time, okay? So I'm not going to take up anything. I can't do it anyways because the rules require me to go ahead and deal with the motion to recuse to begin with. So I've ceased any other business, and that's why I had Mr. Chamberlain reach out to you last night and counsels for you all to be here this morning so I could take this up. Your motion actually was filed last Friday at 10:40 p.m. It didn't appear in the system, however, as sometimes Odyssey happens, until sometime on Monday evening. So when I started to read Mr. Steele's affidavit last night, we were put on notice that there was possibly another affidavit out there and another motion. So that's why we had to call you, okay? So that's how we got here with this. Or else, did you all attempt to send me independently another a copy of that, or?
We did not, Judge.
Okay, no harm, no foul, no. So no, I just wanted to know if you had attempted to do so, because we would have certainly, had we known that, pulled you in on Monday morning, which would have been the closest time that I could have heard your particular motion. So just from a time aspect, I just wanted to account for that. Taking a look at this applies to both motions that have been filed to recuse the court or disqualify the court. Recusal by a Superior Court judge is governed by Uniform Superior Court Rule 25, etc. Rule 25.1 provides that all motions to recuse and disqualify a judge presiding a particular case or proceeding shall be timely filed in writing, and all evidence thereon shall be presented by accompanying affidavits, which shall set fully assert the facts upon which the motion is founded. Filing and presentation to the judge shall not be later than 5 days after the affiant first learned of the alleged grounds for the disqualification, and not later than 10 days prior to a hearing or trial, which is the subject of the recusal or disqualification, unless good cause be shown for the failure to meet such time requirements. And that is cited in Georgia Uniform Superior Court Rule 25.1. So I'm applying that to both sets of motions to recuse. And applying this rule, Georgia courts have held that when a motion to recuse is filed, the trial judge shall immediately, 1, determine the timeliness of the motion, 2, the legal sufficiency of the affidavit, and 3, the legal sufficiency of the grounds, and has no power to do anything else. And that is Robinson versus the state, 332 Georgia Appeals at 242-41. The 3 threshold determinations that the trial judge must make in regard to a motion to recuse are whether it's timely filed, whether the affidavit made in support is legally sufficient, and whether some or all the facts set forth in the affidavit are true, recusal would be warranted. And that is Dacker versus the state, 300 Georgia, 74-77, 2016. The judge finds any 3 of the conditions have been met. No, I'm sorry, take that back, strike that. If the judge finds that all 3 conditions have been met, he must refer the motion to another judge to hear the motion. But if any one of the conditions is not met, there is no error in denying the motion. And motions to recuse are viewed and considered by the appellate court for abuse of discretion. Accordingly, the court is going to address each one of the factors as it pertains to both Mr. Steele's motion and, for shortness, Mr. Banks' motion. I find both motions were timely filed. I find that Mr. Steele's motion was in fact filed on this past Monday, which would have been the 17th of June. I find that Mr. Banks' motion on behalf of Ms. Bumpus was timely filed, as it was filed on the filed on the 14th of June at 10:40 p.m. Secondly, I find that in addressing the legal sufficiency of the affidavit, that means, was it sworn? Was it sworn before a notary? Is in proper form? I find Mr. Williams and Ms. Bumpus's motions to be, or I should say affidavits, to be in proper form. The third thing that the court has to review, and like I said, I reviewed, is the legal sufficiency of your grounds of the motion. And here's where the court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops.
Shocker.
stops
So
the trial.
shocked that you
So
denied the motion.
I'm going to make those.
That's what you do best.
Make that. I'll reduce both of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are the only three things I do. And then if I find it to be not sufficient on its face, I go for it. I just make the ruling at that point in time, let you all take it up. No, I won't grant a motion for a certificate for immediate review. And
Okay, sir. So why have you not
that's
read
where
it?
we are at this point in time. Anything else, Mr. Banks?
If I could just briefly be heard, Judge.
Sure.
Please. And I'm not trying to, I understand the court's ruling and we'll proceed as we see fit. I do take issue with the court's characterization about the legal insufficiency of the affidavits.
Well, that's why when it was reviewed on appeal,
Sure.
it can certainly be, I mean, the appellate court will review my ruling for abuse of discretion.
Certainly
Okay.
understand that, Judge. And in stating that, Judge, I would just say that one of the issues that is raised in our affidavit, because our motion to recuse is to recuse you from the contempt proceeding, not the underlying criminal case in which Your Honor is presiding. And so we really don't have an issue or standing to even challenge that. And so to the extent that there is a contempt proceeding that is set for the 25th, Your Honor, you are a witness to that proceeding. And so because you were a witness.
I don't believe you. I'm not going to get into any argument, but I can't. So that's your assertion at this point in time. And like I said, when that is taken up, I'll consider. I also remember I still need to rule on the issue of the motion to quash. So I may, depending upon what I decide to do at that point in time, other things may be ripe. Okay.
Do you want to hear about the motion to quash, or you want to take?
No, not yet, sir. I'm going to take up the motion to quash after I finish. We finish the direct of the current witness.
Okay.
And to other issues that have been raised, as I've told some of the other lawyers here, there is a transcript of what occurred in the ex parte matter. I will, in fact, I'll authorize defense counsel. I'll do a privilege review and see what needs to be disclosed in terms of impeachment and/or Brady. And for that, and I will do that. And then so if that pertains, or if that issue affects you, then certainly that may be something that at the appropriate time you'll be able to have a look at.
Well, I appreciate the court's time. We would certainly rely upon our brief and our
Yeah.
motion, and that's a part of the record.
Okay, all right, but I will reach out, the court will reach out to you on two things. One, the ability to take a look at the ex parte transcript and review it for the appropriate parts that the court will authorize. And then also for the, I'll re-notice you because I know that it's supposed to be done this Tuesday, but I doubt that we'll probably have it this coming Tuesday.
If I just may say, again, Judge, I know I've already said it as it concerns the issue about you being a witness to the proceeding. We don't believe that that's a bare allegation. We believe that would be an established fact at the hearing. We also.
But I can't take it. It's not something that I can argue with you at this point in time.
I'm not trying to argue.
No, sir. You are an advocate for your client. Sure. That's the only thing I can say, but I'm not going to take up that issue right now. It's part and parcel. You made it part and parcel of the motion to recuse. So I'm saying that at this point in time, I've made my ruling. You've said what you need to say in terms of what your thoughts are. I'm going to reduce it to an order, and you can take what you want to after that. Okay.
All right. Thank you.
All right. Thank you, sir. All right. Mr. Steele, similarly, I'll reduce what I have mentioned to in an order, and you will be able to take it up as you see fit. I'm not going to grant a motion to a certificate of immediate review. Anything else?
I have read Baptiste versus State. I've read all the cases that I believe are applicable. I'm, best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting ex parte with the court and others, and the prosecutor and a witness, and specifically they wrote in a pleading and under Parish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022. The lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just ask you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I ask the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand.
I'm not gonna, Mr. Steele, I can't argue with you about anything such as I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that, you're gonna have to put those in some other pleading. But at this point, Miss Weaver's gonna prepare the record. She does that. And like I said earlier, the record should be ready soon. And you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers. Less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that you have at that point in time.
Thank you.
All right. Okay. All right. Let's turn now to the statements or interviews from January.
Not to interrupt the court, that finishes our business today, man.
You don't want to stick around? Okay. Well, okay. Thank you, Mr. Banks. At all. Okay. All right. Okay. Yes, you may be excused, sir. All right, Ms. Hilton and counsels, what matters do you have to take up from the interview from the the January 28th, 2015 interview?
Your Honor, last night we sent over both the February 21st and January 28th redactions. We sent the February 21st one around 7 p.m. and then the January 28th, probably around 11:30. We have not heard from defense counsel yet, so I'm not sure if they've reviewed them and if they have any additions or disagreements. So we were just waiting for defense counsel to let us know their position.
Okay. Counsels for defendants, have you identified, since now the state has sent you parts from the 28th January interview that you wish to talk about? Mr. Sharp?
Good morning, Your Honor. I have not had a chance to digest their proposed redactions. I'm happy to talk to them about it. I've been working feverishly on getting together the redactions that we believe are warranted. Again, I'd be happy to talk to the state about that. I'd also be happy to go through them one by one with the court, however is favored. But I can't say at this moment that we've cross-referenced the two lists.
Okay, all right, so that's what we're supposed to do this morning, though. So does anybody else have flagged or wish to be heard on the interview for January the 28th? Sure. We're going to cover them independently. Like the January 28th, we'll cover the February 21st, and then we'll cover the June the 10th interview, and then potentially the jail calls.
I believe that myself and Attorney Steele may both have lists. I don't know.
May have what? Sorry, I'm sorry.
Lists.
Okay.
But we're representing different individuals, so the list may vary a little bit. So you may be getting some suggestions from this chair, some suggestions from that chair, and then some suggestions from the state.
I understand.
Yeah. Okay. Your Honor, may we have 15 minutes to just talk to the state about their list?
Yeah. Does anybody else have any statements that they've identified from the January 28th or February 21st or June 10th, other than Mr. Steele or Mr. Sharp, that they want to bring up? All right. Okay. All right, then I'll give you all 15 minutes and you can come back and we can just begin with with the 28th of January interviews, okay? All right. What?
Okay, January 28th for what year, V?
Let's see. People.
Mm, they extra. Extra rules. So what are your thoughts on some of this, V? You hear me? Hanging in, V?
Yeah, I'm here. I hear you. Yeah, I'm here. I hear you. This is a lot longer than 15 minutes, though. This break is super long.
Facts.
So I don't know what this crazy man is doing. I mean, it was just supposed to review the prosecutor and the defense were supposed to compare notes from the January 28th video, and they asked for 15 minutes. So obviously something else is going on. And you got to wonder what that is, because the jury is not even in the building. Lil Woody ain't in the, shout out to Lil Woody, y'all. He ain't in the building. They gave Lil Woody a break today. So I don't know. Anybody listening, y'all put Lil Woody in the comments, man. Shout out Lil Woody. Shout out to Lil Woody, but we hanging in there strong. You know, we just, you know, I know it's a little boring right now for those of you who are watching with us. You're seeing what we're seeing live. Nothing is going on right now. The judge actually denied the motion that Brian Steele filed yesterday, as well as Bumpkiss's attorneys. They filed it Friday for him to recuse himself. He had 3 points that he had to go over to decide whether he was going to move forward with that process. He agreed with the first 2 bulletin points. The third point, he really didn't address. He just kind of skipped over it, like, y'all deal with it. That's the end of it, you know. So this judge is out of control, man. But I pointed out to Almondeyez that she'll chime in when she can, y'all. I pointed out to her that, you know, the judge has a service animal behind, you know, back there on the bench with him. I don't know if y'all paid attention to that. So something is going on with this judge on some mental ish. Remember, he was in the military for 30 years, I believe, the Army. He got a service animal. You know, a lot of these guys ain't really rational, and it doesn't come out until they get some pushback. And a guy like him that's been in the military 30 years, he's not used to getting pushback. He's used to having his way. So he getting pushback right now, and that's stressing him, believe it or not. And it's showing. You know, it's showing with some of his decisions. Because to me, if he was going to disagree on any of the 3 points, it wouldn't have been the third one. It wouldn't have been the third one. I mean, he could have shut it down at the first or the second, but when he got that far, I'm like, oh, he might as well just go ahead and recuse himself now and pass the ball, you know, kick can down the road to somebody else, go ahead and retire, whatever, you know. But sometimes that pride, men have that pride and they can't let go. Especially it's an old line versus a young line kind of thing. And that's the dynamic that's playing out in this court. He's the old line, and you got all these young lines like Brian Steele up in that court. You don't like that shit, man. He gonna be out there hugging on his dog or something. That's what I guess he's doing. He in a room somewhere getting extra love from the dog, so he could get his shit together. I don't know. I don't know. I don't know. But Oh, no, I said she can't hear me. Hold on. Oh, no. Can you hear me now? I just saw in the back chat you put can't hear me. I hope y'all can hear me because I've been running my mouth for a while. Anyway, I'm gonna continue. I don't know. She'll maybe that was a little earlier. I'm not sure, but yeah. So we're just gonna keep watching. We're live, y'all. We're watching this court. The YSL trial. A jury will not be in today, so Little Woody will not be testifying today. This is like a day of motions. And we had a little bit of sparks, like I said, but then like the court started late. We had about 15 minutes of sparks, and now we've been on pause and for about 30 minutes now. So it's like, what the hell is going on? Tomorrow court is going to be closed. It is a federal holiday tomorrow that they're going to observe. That's Juneteenth. Those of you. Yeah. It was kind of funny. I was watching Lead yesterday. Shout out to the lead attorney and AV. They covering the case as well. They were talking about Juneteenth, and they were like, "The hell is that?" They really didn't know what it was, and because it didn't really become a thing nationally until a few years ago. And you'll find that sentiment from people here on the East Coast. That's more of a Midwestern thing. But you were here on the East Coast, understand what June 19th is. The slaves out there in Texas found out late that they was free. Almost 2 years, kind of thing. And June 19th is in recognition of that when they finally caught up with the rest of the world. Remember at that time, you young people that may be watching that's thinking, how is that possible? Well, information didn't move fast as it does today. That's a new thing. And I would say in the last 10 to 20 years, that information start moving as fast as it did. I remember there was times when I was a kid, in the 90s, music would come out in New York and New Jersey, and it might take 2 years for that record to make it down south. That's just the way it was. My cousin was a DJ, or is a DJ still. KL, the architect here in the Charlotte area, York, South Carolina, Rock Hill. He's actually the DJ down at the ballpark down in by Bearden Park in Charlotte here. But anyway, he always would hit me up, hey, cuz, send me some music. So I had to go to the record stores and physically mail him some records and put stamps on the package. And, it wasn't like what it is today. Things were a little bit different. That wasn't that long ago. 90s is only 30 years ago. So same thing. I mean, way back when, they get telegrams and the people running the telegram, they weren't happy that slavery ended. So they ain't telling nobody. We just gonna pretend like we don't know. So that news didn't travel. But here on the East Coast, and Lead is from Georgia. AV is, I don't know where she's originally from, but she's up there in Boston. Neither one of them really knew what June 19th was, which was very surprising. But not surprising at the same time. Not surprising. I know a lot of times, and y'all hear me tell people sometimes in discussion or in an argument or debate, these people are from like the Midwest or Mississippi, Alabama type, New Orleans kind of people, Louisiana. It's a little bit different for them, and I know they think they're the center of the universe and the world revolves around where them and where they are, but we don't. Nobody goes to those states. I'm not going to include Louisiana. Louisiana has New Orleans, and that is a tourist attraction. There is no real tourist attraction in Alabama. There is no real tourist attraction in Mississippi. So most people from the East Coast, if they go to those states, it's because they know somebody in those states. They got family there. Those are drive-through states or flyover states for us. You know, that's not a destination. Hell, we're more likely to go to Texas before we go into Louisiana. I mean, go to Alabama or Mississippi. You know, East Coast is the East Coast. Now they're Southeast. Technically, they get kind of mixed in that region. I don't think it should be, but they are. But East Coast are the states that actually touch the East Coast. You know, and that's where the majority of black folks live in this country, on the East Coast, in the Southeast. You know, I know that's a big pill for some people to swallow, but that's always been that way. That's why most of us have lineage that traces back South Carolina, North Carolina, Georgia, Virginia. That's where we got off the boat. That's where they put us on the auction blocks. So that's where we originate from. You know, the vast majority of us. I'm trying to get y'all a little entertainment while we waiting on this judge kicking in. Yeah. But we are streaming live on Almondeyez 78. We also are streaming live on the
Okay, all right.
simulcast
Okay.
on the
All right.
People's Podcast as well.
How much longer
So,
we all need?
trying to give y'all options. Here we go.
They have had an opportunity to identify, or to review the redactions. I'll let him speak for him.
Finally.
All right, sir.
Not quite what I said. We've identified things that we think need to be redacted. The problem, the mountain we're climbing is both sides have their own transcript and the pages are not the same. So we're working off two different transcripts, and we have converted our files to MP3. They're still going off the evidence reviewer. So we're working off two different transcripts and two different videos with different timestamps. So we've figured out a system to try to make it work. It's just a little bit time consuming. So we're working on it. We have identified, and we're going to get to the state what our proposed redactions are, and we still have to cross-reference their redactions. So it's just a time consuming process.
Okay.
We're working as quickly as we can.
If they have redactions that they have identified at this point and they would like to turn them over so we can review them, and if they turn over both the transcript that they are using and the MP3 file that they are using that corresponds with the redactions that they've requested, we could review those. We could at least be reviewing those while they're correlating the ones we've given them to the media that they have and the transcript that they have, so that the downtime isn't a total wash, and we'll be able to make some kind of progress.
All right. Sir.
I will see if we have. We should have a copy of the MP3s. I don't think we have a problem with that, but we'll figure out a way to get them the information so they can reference their materials so they can see what we're suggesting.
Okay.
And we can literally listen to it in their media format, however they give it to us, and we can know whether we agree or disagree with it in the format that they have it right now.
Okay. So how much longer we all need?
Well, we are nearing the end of the January 28th statement. I don't anticipate the February 21st will take us quite as long. I anticipate the June 10th will be very lengthy. So if you're asking to address those two statements, I think that we could be ready in probably 45 minutes to an hour. But regarding June 10th,
Okay, well, let's just bifurcate it. As you all told me before, the June 10th one will take the longest, so.
Right.
But you have identified most of those statements, is that correct?
in June 10th,
Yes.
yes.
Okay, all right.
And the good news about June 10th is we're actually working on the same transcript on that.
Okay, all right. So do you all want me to give you another 45 minutes? Let's say we recess and have come back at 12:45?
So we'll be discussing the January, which ones will we be discussing?
January 28th and February 20th.
21st. At a minimum.
Okay.
Yeah, I'll have to, we'll take up the June 10th one. I had planned on, once we kind of finish those two, we can kind of get an idea what would be an appropriate schedule, okay?
Yes, sir.
All right. That work for everybody else? Okay. All right. All right, we'll see you all back at 12:45, okay? All right, okay. More recess.
All right, y'all. Let me quickly explain what just happened. What they were talking about is some kind of way the prosecutor versus defense got two different versions of the video file in different formats. I don't know how that could happen. I don't understand why they're working on like MP4. He said MP3 in court, but MP3 is audio. MP4 is video. Some kind of way somebody's using the MP4, somebody's using another format. I don't understand how that happened. They should be looking at the same format. And this goes to what I say. Education doesn't mean intelligence or you're smart. It means job placement. So these people to do their job, they're not experienced nor trained in these basic formats. This is stuff high school kids, elementary school kids know how to manipulate these files. So, and when the files change, they're also out of sync. Because I would assume, I don't know what other file they said. I didn't hear it. I'm assuming just what I know was like a VLC format, and they may have used a different codec for whatever reason. And the codec, the timing is off. on the video. It don't sync up, even though they're using different formats. You think, oh, the video should, 10 seconds. If you look at 10 seconds in, or a minute and 10 seconds should be the same exact spot on both files. No, it's not. So it might be 90 seconds on one file and a minute and 20 seconds on the other file. So they can't do timestamps, if you follow me. That's the problem that they're having. They're trying to match it up with each other. I think the way they're doing it is very difficult. They should have just, when they realized that was the problem, they should have started from scratch. Okay, we're going to use, this is the file we're going to use. Make sure we're synced up, like you line up your watches, everybody's synced up. Now go from there. That's what they should have did, instead of trying to play this timestamp game, because that's going to be a lot of back and forth. So they recessed for that, and they're going to be back supposedly at 12:45. And what I assume is going to happen, they're going to go to lunch after that at like 1 o'clock. So I don't know what this game is they're playing. I don't know why they're playing this game. Now, also, somebody said Lil Woody is supposed to be live on Instagram. I don't know. We'll see if Almondeyez can try to find that, and if she can, maybe we'll switch to that. See what Lil Woody talking about, and we can get some little Woody fix today. We'll see. But stay tuned. We're gonna keep up with this. I might run out myself for a little bit, go get some lunch. While all of this timing, but I'll try to keep up with it and pop in it. And
what did you want me to find, D?
Huh? What you said?
What did you want me to find?
Lil Woody's supposed to be live on
What did you want me
Instagram.
to find? Oh, okay. Let me see. Let me see what I can find.
So it's not a lot of happening. So we kind of just letting it play, y'all. Just to give y'all another stream. I know they're streaming all over the internet. We trying to make sure our people.
That ain't him. Hold up, this ain't.
Y'all Spartans.
That's not him.
We trying to make sure y'all Spartans have, y'all can watch it at home with us. You ain't gotta go to nobody else's channel. So that's what we trying
that dude that's streaming as Lil Woody, that ain't him.
That ain't Lil Woody? Oh, okay. See, you heard it here first.
Nope.
I'm keeping up with a couple of channels myself, and I just heard somebody say it on another channel. So,
unless he got another handle, that is not him.
He better stop talking. But that's it, man. That's what I got. Like I said, we just want to make sure y'all had a place come home here with us. And, we try not to interrupt. Obviously it's not much going on, so it's nothing really for us to interrupt. But we'll chime in here and there. Myself or Almondeyez will chime in as we see little things happening or become aware of things, and try to keep y'all up to date and up to the minute. And we appreciate y'all rocking with us. All right, I'm out of here. I'll be back.
Well, B, give us some history on what's been going on. So for those who haven't been watching.
Yeah, I talked about it a little bit earlier. Earlier, in case y'all just now chiming in, the judge was he was reviewing Brian Steele's motion from yesterday, as well as Bumpkis's. He was responding to it. Bumpkis lawyers were in there for which she filed on Friday, 10:40 p.m. Now, he did give a good explanation why nobody saw it. He says sometimes when you put things into that system late, it doesn't show up until Monday morning. Well, they was in court Monday, so nobody paid attention until after they got out of court. And that's when I became aware of it. So that made sense. obviously her lawyers was trying to get it in at the last possible. You know, that's just like news cycles. A lot of times where they drop that bombshell, you'll see it happen Friday late. And so that way it gets into the weekend cycle and they get as much traction for it all over the weekend. For example, with Joe Biden with the G7 thing in Italy on Friday as well. That happened Friday when it got released to us. But it had actually happened earlier in the day on Friday. We could have known about it earlier, but the news station's cycle didn't drop until late Friday or later in the day on Friday, or whatever it was. So it ran all weekend. And I mean, that's just how it goes. It's a political game people play, and you know, strategic things of that. But the judge essentially, it was 3 points that he identified as part of Georgia law, section 25, whatever, etc. I think he said, and he agreed with the first 2 bulletin points. But then when he got to the third point, whether to recuse himself, it was 3 points, and he didn't even respond to the third point. He kind of made some comments and moving on, like I don't think he wanted anything on the record about his disagreement, because if he already got past the first 2 bulletin points, to me, the third one should have been automatic, you know, basically, which was just case law. Did the lawyers properly use case law? And they did. Because if they didn't, he wouldn't have agreed with the first 2 points, which was based on case law. And if you read the Brian Steele one, he cited a whole lot of case law. And then when Brian Steele tried to talk to him about it today in court or respond, I'm not going to argue with him. He just kept cutting him off. You know, again, this is a military guy, the judge. He got his service animal back there. He got some mental issues, but he's an old man who's used to getting his way. He's also from a different time period. He spent 30 years in the military, right? So that means, I mean, and then I don't know how long he's been a judge. So this man is an old guy, and he's used to not being told no or not getting his way. So as I mentioned earlier, he got the young lions challenging him. He's the old lion. You're seeing that dynamic play out, especially with him and Brian Steele, because Brian Steele is not no spring chicken. He's been practicing law for 30 years himself. So he like, look, you know, so you got 2 alphas, kind of, to make this simple for y'all. 2 alphas going at it. And I think this judge is going to win, but he's used to winning. I don't think he's going to win. Brian Steele be coming for him. And remember, Brian Steele's lawyer, his lawyer is what's the white lady, Merchant or whatever, from the other case. See, all of these lawyers know each other. They all connected. And they all about sick of Fannie Williams, because this is all of this all ties back to Fannie. I don't know if y'all really, you know, those of you who've been following this YSL trial have also been, hold on a second. But those of you who have been following this YSL trial have also been following the Donald Trump trial. Both of these are RICO cases. And all of these lawyers, they about sick of Fannie. I'm telling you, they sick of her. Because this is all her mess. This is all her mess. Hold on, man. I'm trying to get my charge right.
Ain't that the truth? Total and completeness.
And there's a third RICO trial behind this one that hadn't even started yet. So yeah, this is it's a mess down there in Atlanta. That's all I know.
All you know how to do is so that you need to go back and reconsider.
Say what?
Yeah. I said, if all you know how to do is bring charges on Rico, then you're not real good at your job.
Right, exactly. I mean, power corrupts and absolute power corrupts absolutely. And I think that's what we're witnessing with Fannie. She's a, essentially she's behaving like a DEI hire. She's somebody the Democrats push through the election cycle. They have their favorites, and she's really like, she's not really doing the people. She's not serving the people. She's serving herself. And while all of this is going on, y'all, all of this stalling is going on, what we're witnessing live, people are sitting in jail. People are sitting in jail for years beyond what they're supposed to be. They haven't been in trial yet. They haven't been convicted yet. They just sitting in jail awaiting trial because of her. Now, a lot of it she inherited, but she's added to it. Because she ran on the fact that she was going to improve what the last guy did. No, she's made it worse. She has made it worse. I'm glad we don't have that going on right here in Charlotte. I swear. I swear. Hold on a minute. But yeah, I don't know what else to say. I mean, this is disgusting. The Democrats supposed to be these moral people. They're supposed to be looking out for black folk. All that. That's what we've always been made to believe. And we see it in action now that cameras are being more prevalent in court. And we're seeing how these people really operate. The judge is black. The DA is black. The defendants is black. Honestly, the only people that's fighting for the black folk is the white guy. Ron's still going hard. The judge is on some bullshit. The DA is on some BS. They supposed to be the ones that we put in place. What did Dr. Claude Anderson tell you? When y'all seen the clip I play on my channel. And where Dr. Claude Anderson is telling you, you don't put politicians in office just because they look like you. You got to make sure they're going to do something for you. That's the mistake black folk been making. He made that video clip way before this trial. Did he not call it? And you see it all over the country. We put people in office that look like us. Skin folk ain't kin folk. We don't remember that. We put people in office that look like us, and they screwing us over, and they going for self all over the country. We got the girl up there, and what was she? Was that Rhode Island? And she was the state senator up there that was twerking upside down and with the beach, and the LGBT element OP girl. Her. We got Tiffany Haynold acting crazy up there in Dalton, Illinois. We got the other girl down there in Macon, the new one. I forget her name. Crockett, I think is her last name. We got Ketanji Brown wilding out on the SCOTUS with, she with corruption, you know. Fanny wilding out. I mean, the girl up in New York. I mean, and the other judge up in New York who wouldn't recuse himself, Mershon, on the other Trump case. Right? I mean, we don't see the empire is falling. We don't see this. But people lying to you, telling you things have improved, specifically during the last 4 years, really. We're seeing things in the last 4 years we've never seen before. Never. And the Democrats are in charge. How do you rationalize that? How do you reconcile that, people? But that's something to chew on. We'll talk about it. We're going to talk about it. I'm going to go live later on. I got a couple of topics I want to talk about later. And I'll throw y'all little appetizers when I come back from lunch. What we gonna talk about? But one of them is gonna be and Almondeyez is gonna love this. I ain't talked to her about it yet. But maybe we'll broadcast it on both streams later tonight, so everybody can see it. Black men need to stop fighting each other because of mama trauma. You're quick to fight a man, but you bitch up around your mama. Ain't that something? Ain't that something? See, these feminists and all, they always using the word mammy incorrectly. Oh, she's a mammy. Mammy ain't somebody who want to get married. Mammy was the single woman who took care of the white man kids. They always using words incorrectly. But everybody like to kiss up the mammy. That's what mammy was. Oh, mammy, 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 I want you to love me. I want you to, because mammy was the one running the house. You know, that's who mammy was on the plantation. She wasn't trying to marry no black man. She wasn't a pick me, as you call it. And that's not, y'all even use that word wrong. It's pickany. It's not pick me. It's pickany. I swear. I'd have to get a whole new dictionary for y'all people to translate what y'all mean versus what y'all really saying so y'all can see how stupid it is. I'd need to publish a whole book, a whole dictionary. How y'all just screw up words. Y'all miss slang up with ebonics. Ebonics and slang ain't the same thing. That ain't what ebonics is. But y'all have totally tore that word up. Ebonics was a teaching strategy for teachers who weren't familiar with black people per se, and to help a particular demographic of people get their SAT scores up. So, for example, black people don't typically use the word sofa. We use the word couch. Whereas the teachers didn't understand, why we weren't getting that. So that was the ebonics. That was part of ebonics to understand how to speak the language that they were speaking. Couch versus sofa kind of thing. A car versus a whip, or a Jeep rather, or an SUV versus a Jeep might be a better way of saying it. Those kind of words. In the beginning, when SUVs came out, we just called them all Jeeps. But Jeep ain't correct. Jeep is a particular company. So you can't call an Escalade a Jeep. White people was getting confused. Black people, oh yeah, he was riding by here in a black Jeep. And we if you're talking to white people, they didn't know what we were talking about. So that was the ebonics to bridge that gap. I'm getting off of here, man. I can go forever, man. We'll come back. I'll be back. I gotta eat.
right, guys. Yeah, we'll be back. What do you say, 12:45? So, well, no, it's about 30 minutes or so. We might as well keep the party rolling. We're gonna keep the party rolling. We're gonna see what else is popping around here. We might pop in and see what's going on with the lead attorney real quick. Y'all give me one sec. Mm-hmm. Nothing. You be talking so they don't be kind. So let's see what's happening.
You got the criminal contempt, and then you got the civil contempt. Civil contempt is what you guys run into with child support. That's child support. So many men, hundreds of thousands of men in jail on child support. Why? Because you owe $3,000. You owe $5,000. Or alimony. We need to check on that damn Nathan Wade case. Nathan Wade does not want to pay his wife $4,000, and they filed a contempt. What is that? That's civil contempt. What are they saying? You, Nathan Wade, y'all know Nathan Wade, who was dicking down Fannie Willis for $750,000. Shout out to Fannie Willis. And Fannie Willis was like, listen, I know I'm 53 years old, and I know, I'm not in my prime anymore, but I know how to get some dick. All right. I'll pay one of these black men around here $750,000. Y'all women can go be celibate if you want to. I'm gonna be a new celibate woman. Fine. Fannie was like, hell no, I need somebody to bend me over this damn fax machine.
Oh my God.
Fannie's gonna get it. All right. Fannie's like, I will let these taxpayers pay $750,000, but I'm gonna get me some. Y'all women can be celibate if you want. Anyways, Fannie Willis was having sex over the fax machine with Nathan Wade. Nathan Wade is married. All right, we ain't gonna talk about all that. Nathan Wade's got a whole wife, and Nathan was supposed to pay her $4,000. He did, and he said, "Listen, baby, I ain't got it." The wife was like, "You just got $750,000." Nathan said, "What the hell did I tell you? I ain't got it." Right? You got $750,000. Okay, let me be more specific, since you can't hear earwax. I don't have $4,000 for you. Don't look at my $750,000. I don't have $4,000 for you. Nathan's wife is represented by Andrea. So Andrea filed a civil contempt. What does Andrea want? Now, she wants a lot of stuff, but she wants the $4,000. What does she anticipate the judge is going to do? The judge is going to say, okay, wait, okay, Nathan, wait, here's the thing. You need to pay her $4,000.
That's a dirty shame.
So,
dirty shame.
Did you bring a check to court? I didn't bring a check. You didn't bring a check? I didn't bring a check. Okay. But you owe her $4,000. I do owe her $4,000. But you didn't bring a check to court? Did you bring cash? I didn't bring cash. Okay. So you don't have any funds to pay her right now. I don't have any funds, Judge. Okay. All right. Here's what I'm going to do. Bailiffs, take Mr. Wade into custody. Wait, Judge. How long I got to be in custody? You decide. If you pay this lady $4,000 right now, you don't go into the back. You're good. You walk out of here. If you want to pay her tonight, that's fine. We'll let you out as soon as the $4,000 hits her hands. If you want to pay her tomorrow, but here's the thing, Nathan. If you want to pay her a month from now, then you sit in jail a month. If you want to pay her in 3 months, fine. She'll get paid in for 3 months. You will be here in jail for 3 months straight. You get the keys. It's not like this if you commit a rape. It's not like this if you commit a murder. It's not like this if you commit aggravated assault. You don't get to decide how long you stay in jail. With civil contempt, it's interesting. You get to decide how long you stay. I will go to prison for 30 seconds. I don't give a damn. If you want to put me, fine, I'll go. Shit, I'll go. Yeah, I was a felon. All right, I was in prison for 30 seconds. I'm a man. All right. Now don't sentence me to 17 years, because then you're not letting me decide. You're telling me the term of imprisonment. I don't want that. I want to be the one. You can send me to ADX. You can send me to the hardest prison that you want. If I can stay there for half a second, I'll go anywhere. So that's what Nathan Wade is up against. The guy that was dicking down Fannie. He gets to decide for $4,000 how long he stays in there. For this case, what is she saying? She's saying that you ordered me to show up because you want to find the mole. Fine. Now, suppose you find the mole. I say it's me. Do I get to determine how long you put me in jail for? If I get to determine, it's civil. If I do not get to determine, it's criminal. Does anybody remember Brian Steele? The judge told Brian Steele that he had to be in jail for 20 days. Was there any way, guys, listen, was there any way for Brian Steele to lessen that amount to 10 days? Was there a way for him to lessen it to 5 days? No, it was a term of incarceration. It was fixed. So Brian's is different. Brian doesn't have the keys to his own incarceration. The judge says 20 days, it has to be 20 days on the dot. So Brian's is direct. All right, so guys, for you, question. Is Kayla, Miss Bumpus, is her incarceration, because that's what she's looking at, is it going to be in her hands or is it going to be in the judge's hands? Can she go to jail for 30 seconds? Or is the judge going to try to do her like he did
Brian,
and then give her 20 days? Mm-hmm. That's the bad kind. The bad kind is when you do not have the keys to your incarceration.
And is she going to have the same connections to get it through the system and get the Supreme Court to overturn it? Probably not.
Facts. So this is what she's saying right here, guys. She's saying, listen, this is what civil contempt means. This is what criminal contempt means. So here's the thing. She says, the contempt alleged by this court, Judge Glanville alleging this contempt, could only be criminal because there's nothing I can do to purge or lessen the contemptuous act, and any punishment would amount to criminal contempt. She's saying that I can't pay $4,000 and walk right out. Brian Steele couldn't pay. Well, that's where the judge fucked it up a little bit, because the judge wanted him to, well, listen now, the judge called it criminal, but this is where the judge got confused. So y'all are seeing the chief judge get confused, because initially the judge wanted to lock Brian Steele up until what? Until he gave a name. Mm-hmm. So the judge said, Brian, ¿por qué todo esto? Why are you making a show? Just tell me who the name is, and you don't even go to jail. Tell me now. You don't go to jail. And Brian wouldn't tell. Fine, listen, Brian. And the judge said this specifically. Once you get back there, if you tell me the name tonight, you get released tonight. In that situation, the judge was trying to give him the keys. The judge was like, listen, call me on my phone. You tell one of the workers down there at the jail, have them call me on my phone. I will get you out tonight. You don't have to do 10 days, 20 days. You don't have to do any of that shit. Just tell me who the name is. Once it became clear that Brian would never tell, and the judge on the record said it was criminal, fine. The judge was locked in, and he could no longer force Brian to tell the name. He could no longer give Brian the keys to the court. So it went from civil to criminal. Mm-hmm. And when it was criminal, it's a fixed amount of time. The judge says 20 days. Don't have anybody call me to tell me shit. There's no way it's going to be lessened. 20 days on the nose. That's what you're going to do. All right. So she goes on. Miss Bumpus goes on. No contemptuous conduct occurred. Interesting. Before we get to this, guys, let me give a big shout out to Call Me Tazzy.
Tazzy.
Y'all see him right there. Y'all see him. Vanessa said the hotline bling. That is the hotline bling. Call me on my cell phone in the middle of the night. I get you out of jail. Shout out to Call Me Tazzy. Thank you so much, Call Me Tazzy. Y'all see him. He says, now I know I got some bad eyes, but if my sight serves me well, did I just see Woody on Instagram Live? Oh, yeah. The lead was about to get held in contempt for witness tampering. Because I wanted to hear all about that secret meeting. I was going to go to jail for you guys. That would have been some content. Somebody write Call Me Tazzy. We got a new co-sponsor here. Shout out, somebody write Call Me Tazzy in the chat. Y'all know I don't ask y'all for anything. And I'm sure that that Friendsgiving will not mind at all, even though she put 500 on it. I'm sure that she will not mind at all me calling Call Me Tazzy as a co-sponsor, and Call Me Tazzy. And y'all go check out Call Me Tazzy's YouTube channel. He not only is he a high value man, but he is a content creator as well. If one of the mods could drop Call Me Tazzy's link in the chat. Thank you so much, Friendsgiving and Call Me Tazzy. Thank you, Call Me Tazzy. And thank y'all for shouting out Call Me Tazzy. He is sponsoring the stream that all 12,752 of y'all are watching. Mm-hmm. Shout out to Call Me Tazzy. All right, so Kyla is saying, listen, I ain't do nothing. what was Woody? What do you keep saying on this thing on this live? Right? I didn't do nothing. What I do? I ain't do nothing. That's what he kept saying on the live, right? Mm-hmm. And what is she saying? What is Kayla saying? Kayla's saying the same thing. I ain't do nothing. What did she say? Kayla writes, there neither is nor was anything preventing the disclosure of this ex parte meeting to the defense counsel. And guys, I got to stop right there. This is huge. You can't be in contempt for not paying $4,000 if there was no order for you to pay $4,000.
Right.
There has to be an order, right, for you to be in contempt in this way. You can't just say I'm in contempt, but then there was nothing that I violated. I didn't violate any rule. I didn't violate any code, any ethical consideration. I didn't do nothing. If you didn't do nothing, you can't be arrested.
Yeah.
Unless you're black. All right, we're gonna go there. Right? We all talk about race, guys. We're only one race.
Just one. And it's so different from Brian's, because Brian, he was forced to give up a name, right? Yeah. Whereas with her, he did not start the ex parte meeting saying, guys, this is not confidential. He didn't give them any warning. So that's why Kayla's like, what did I do? You know? What did I do?
Exactly. Did somebody say Arturo's in the chat?
I think I saw him. He referred to himself as the real law daddy.
That probably was Arturo. That was definitely Arturo. That was definitely.
Hold on. Let's give him the.
Wait. What did this nigga call me? Hold on, right quick. AB, talk to him. Let me see if I can get Arturo out here.
That would be cool if we can get Arturo.
Talk to the folks, man.
Yeah. And
do you have this?
I can read these. I can read these in the meantime.
Read those, and then let me email you the document that we're reading so you can maybe share the screen too. But yeah, start off reading those.
Okay, cool. So I'll start off with some cash apps. Shout out to Daniel, who sends me $5. Thank you so much, Daniel.
Thank you,
Coach
Daniel.
B sends me $15. Thank you so much. And he says, you are appreciated.
Yes.
He or she. I think it's a he. Thank you so much. I really appreciate that. Jason is here with $5. He's back again. He says, back from test, waiting on results. Thank you. Again, Jason, I really hope it's negative. Okay, so
shout out to Jason.
Fingers crossed. I know you're going to be okay no matter what. So thank you so much, Jason. And then a shout out to Erica, who sends me $5 and says, how can Woody join the live if he's not a member?
Wow.
Like, would he be able to get in the chat?
Wait. Well, how is Arturo? How did you see Arturo? Is he a
Arturo
member?
just became a member like 2 minutes ago.
Are you serious?
And
Arturo,
then-
call me, nigga. Like, what are you doing?
And then he said, the real law daddy is in the house.
That is definitely Arturo. We got Arturo Corso in the house. Shout out to everybody.
Where you at, Arturo?
This is, I ain't even going to tell you, regale you guys with how powerful this man is. High value man. First of all, he's super wealthy. He's rich. Y'all know Ashley Merchant, who swooped in and saved Brian Steele. Brian Steele is a member of GACTL, the Georgia Association of Defense Lawyers. The person that swooped in and saved him was Ashley Merchant. Ashley Merchant is a member of GACTL. In fact, she's the president of GACTL. It's one of Georgia's most powerful associations. Who is the president-elect of GACTL? Arturo Corso. Handles felony grade charges, also federal cases. You don't know whether you're going to find him in Atlanta, in DC, in Texas. He is also down so many times in Mexico representing the cartel members that are doing what cartel members do and have been or in the process or fighting against extradition to the United States. Arturo is a man's man. However, saying that, he's super sensitive, really fights hard as hell for minorities, fights hard as hell for the downtrodden. Him himself being from Colombia, he takes that very seriously. He is a warrior. He handles so many cases, even though he's one of the highest, most expensive criminal defense attorneys in the state. He does so many cases for free, which is something that usually attorneys do not do. Y'all hear about pro bono? Pro bono is like a unicorn, man. You hear about it, but you don't see it. He does so many pro bono cases a year. So Arturo Corso is the absolute man. He is my best friend. He is my law partner for so long. And just an excellent attorney. So shout out to Arturo. Did you read the Cash Apps?
I did.
Okay, I sent up the let me see if I can well, yeah, go ahead. I'm gonna text him, but I don't know if you can
Before
pull
you
it up
do
on
that,
your
hold on, let me see. He just dropped you something.
Where is he at with it?
Bam!
Oh, I got some cartel money. Oh, I got some narco money. Oh my God.
You just got hit by the law daddy with the C note.
I got some cartel money. El Chapo. Thank you so much. Again, Arturo, my best friend, law partner for so many years, and just a brother to me, an absolute brother. I'm guessing because he's in the chat, he can't come up. I'm gonna drop the link for him if he can come up. He probably can't, but I'm gonna drop the link for him if he can. Guys, this link is only for Arturo. But thank you. And Arturo, if you will do something for me, if you're listening, if you can put the GACTL, fundraising thing, the fundraising link, that way we can pin it to the top. So for the link, and there are 12,000 people in here. I had to get on Arturo a little bit, man, because it's like GACTL is so powerful and does so many things, but they need money. But what's the problem with GACTL? It's run by attorneys. It's not run by marketing people. It's run by old school attorneys who are kick ass. Ashley Merchant, Brian Steele, Arturo Corso. These are the freedom fighters. They ain't got time to be thinking about, I need to post something on TikTok. I need a YouTube channel. Consequently, what? GACTL does not get the funding that it absolutely deserves.
I just found the link for that, for the donate, because he's saying go to the donate page. I just
see, that's the problem right there.
Yeah.
There are 12,000 people in the chat. And I tell Arturo to send me the link. And what does he say? No, tell the 12,000 people to go and find it. This is the problem. They don't understand. I love Arturo. They do not understand. There's 12,000 people in here. And Arturo's talking about, just tell them to go and find it. You need to remove barriers of friction, Arturo. Make it easy for them to send you $5. Make it easy. All right. So this is my brother right here. We got him in the house. Let me bring him up. We got Arturo.
There he is.
Just waking up from the damn beach. We got my brother in here. My brother is telling y'all, if y'all want to send money Go click on 30 buttons. Click on 30 buttons to come and send it. All right. Arturo, can you hear me, brother?
I'm getting an echo like 30 seconds behind.
You're 30 seconds. Well, all right. Close out the YouTube and just watch us on the stream.
How about
Close it
that?
out. Can you hear us better now?
Yeah, man.
All right, now he's working. Now he's working. Listen, we got Arturo Corso in the house, guys. And I'm telling you again, this is one of the premier concierge service criminal defense attorneys in the state. One of the
You need to stop that. You're making me
listen.
blush.
He's like, oh, don't keep bragging on me. Tell me a little bit more. Tell me a little bit more. I'm the law daddy, right? You know, and I'll be honest, all of the best criminal defense attorneys, they got a little bit of ego because they're kick ass and they've been kicking ass for so many years. And so who you guys are looking at, my best friend, my law partner for so long, and my brother, again, he is the president-elect of GACTL. Can you tell us a little bit about what GACTL is and why it's so important?
First of all, the two of you guys look so great today. I'm embarrassed to be showing up like this, but I couldn't let you go on.
Listen,
First of all,
and let me just say this too, guys. What criminal defense attorneys do is it's a carrot and a stick. All right. The stick, of course, is taking these prosecutors to trial. But all trials involve risk, especially when they're felony grade, especially when they're Fed cases. What you would like to do is achieve the best result for your client, regardless of if it's a trial or if it's some type of agreement. And so when you're starting off, typically with these prosecutors, you know, you want to get on their good side. You catch more flies with honey than vinegar. So y'all saw a little flash right there of the schmoozing, you know, that is just innate and excellent criminal defense. Oh, you guys look so good.
it's all about the relationships.
Yes.
Relationships.
Arturo taught me that way back.
Years.
Yes. Arturo's been practicing maybe 10 years longer than me. And so he put me on game on so many things, especially with these criminal cases. Because guys, I'm not a criminal guy. I've represented people, but usually almost always it's like misdemeanor stuff. If it's higher stuff, then they all go Arturo. But there'd be times when Arturo would be like, hey, Lee, go on and take this case and put some money in your pocket. I'm like, I don't want to take this case. Arturo would be like, listen, I'll just do it. I'll tell you what to say. Go on and get your money, pimp. Like, I ain't gonna tell you how great a brother Arturo is. He's like one of the #1 criminal defense attorneys in the state, just an expert. But he, you know, when he says, you know, all this whole thing is about relationships, the relationships that you have with prosecutors, really sometimes the relationship that you can establish with the jury members, the relationship that you have with these judges. We're seeing now Judge Glanville and, you know, how his relationship with Brian Steele.
Don't forget the cops.
Don't forget the cops.
Because that's the first line out in the field. You don't know how many times I've gotten, it sounds bad to say it this way, but gotten away from a traffic stop just because you know how to talk to cops. Maybe they recognize you, treat them with respect. It's a good life lesson, but yes, sometimes we get more flies with honey than with vinegar. In fact, one of the reasons I look like this today is I was on a Zoom with Judge Deal in Hall County trying to get somebody a bond, who's been in jail for a week. And when the judge stepped off the bench, I just turned on my camera and my mic and I hollered out to the prosecutor and I said, hey, prosecutor, how about giving me a bond on this case? She turned around, she's like, oh, hey, yeah, I'd be happy to consent to a bond. She filled it up. She writes it up. She hands it up to the judge, signs for me. I'm back at the beach. I don't even like the beach, but I like getting stuff done for my clients like that with honey. With the honey.
Yes.
Speaking of honey, AV, you looking
Here we go. They can't turn it off. They cannot turn this shit off.
I can feel that heat. I'm 500 miles away. I can feel it.
Listen, these it's in them, and this is why Arturo is just so amazing. Like, you know, most attorneys, 98% of attorneys, we are all looking to get out. We're all looking for a way to retire, just to get away. And Arturo is one of the special golden 2%. that want to be in. They never want to be out. They love the fight. They love pursuing justice, even though it's so hard, so aggravating. What we're seeing in this case with Judge Glanville, you guys have no idea how many, I don't want to say corrupt judges, but judges that are making ill-advised and wrong decisions that Arturo has fought against for so many decades. Most people are like, I don't want to do that shit. But that's why Arturo is so special, because he just loves the fight.
Arturo, did you know that you have a troll in our chat?
Is there a troll? Was it Arturo's like me, man. We don't really know what's going on. Who's the troll?
Probably the girl I'm supposed to be with.
Oh my, no,
vacation.
Here we go, right? Shout out to Arturo's Burberry collar. I don't know if you can see that. Mucho gusto todo, getting dry clean currently. Arturo, this is special when you have your own troll. I have the best trolls on all of the YouTube community. And I was, that me and you go to the same private tailor, and I'll just let the tailor do anything. But you're like, no, you design your own shit. And they saw that Burberry collar that you had on the last time, and somebody took a photo of it, and now your Burberry collar has its own presence here on the channel.
That
so
doesn't
thank you so
sound
much.
like a troll. That sounds like a fan.
It is.
It's a thin line. It's an absolute thin line.
Yeah, they have made some pretty cool ones. One time they put my face on his body, and it was called
hilarious.
the light-skinned attorney. So
the light-skinned attorney. They have one of your feet.
They have one of my feet. It's two chicken feet crossed, and it's AV's feet. So
AV's feet. Yeah, so there's a ton of trolls.
We have Leeds' third button.
Oh, the third button trying to escape. All right, I'm going to free my brothers. That is exactly right. So Arturo, again, because I absolutely want to get back to this, because the GACTO organization does not get the credit that it deserves. Can you tell us a little bit about GACTO and why it's so important?
Yeah, so thank you for bringing that up. And you were so right when you say we're a bunch of lawyers and we are not very good at social media or self-promotion. But I can tell you that GACTO, which is the Georgia Association of Criminal Defense Lawyers, we are 1,500 Georgia defense lawyers all across the state who get together and collaborate. We're just like a big firm, a big partnership. So we have a listserv where we can talk about cases, we can educate. We have several arms of our organization. One of them is the Georgia Criminal Defense Lawyers Educational Foundation. And through that 501c3 charitable organization, we run 3 scholarship type programs. And the most exciting one by far is what we call the Bill Daniels program. We bring in young lawyers and we teach them how to do battle in the courtroom with these prosecutors. Just like these prosecutors get training on how to prosecute cases and put our people in jail, we teach young lawyers how to fight against that, how to stand up for the Constitution, how to know the law, and yes, how to stand up to some of these bully judges. What Brian did is really spectacular. And I want to go back to even the Friday before he was held in contempt, where he was telling that judge, you are biased. You have been coming after us from the beginning. We're not getting a fair trial. You're allowing the prosecutor to say these outrageous things about we attorneys, sometimes in front of the jury, and you're not standing up for us. So we're going to have to stand up and say, look, you need to put a stop to this. Specifically, I remember the lead prosecutor, Miss Love, alleged that Brian Steele had, instead of providing some video or some audio recordings from another jail of a witness, she said he went in and deconstructed the digital footprint and removed something, making it hard for them to play it, and then handed it over, which is preposterous. Brian Steele is a lot of things, but he is not a techie. So she made that allegation on the record, and the judge was like, okay, well, he'll have to fix it. Finally, Brian stood up and said, what the hell is going on here? He said, I used to love coming to court. This was his church. But now he doesn't even want to come to court anymore because he's being treated so badly in the courtroom by the prosecutor, by the judge, and it all spilling over to his client. And that means that Young Thug is not getting a fair trial. Finally, today, you're going to see some press coming out soon, if it hasn't already, that Brian has filed a formal motion to recuse Judge Glanville. That means to take him off the case for being biased in the case.
Mm, interesting. This is so crazy. You know, when Brian Steele was attempting, or when the Judge Glanville, more correctly stated, was attempting to incarcerate Brian Steele, you know, the Gactel stepped in and through Ashley Merchant, and there was something being mentioned about the strike force, the
Yeah,
strike
that
force
strike
arm
force.
of Gactel. Can you tell us what the strike force is and how that played into Brian Steele not going to jail indefinitely until he released the name?
We have 30 highly skilled defense attorneys on call 24 hours a day, 7 days a week, 365 days a year to respond to any crisis from one of our members. So, of those 1,500 statewide members, if anybody's in court and is being threatened with contempt by a judge, they can pick up the phone, push a button, and we'll have 1, 2, 5, 10, 30 lawyers there in minutes. And we've got them all over the state ready to respond. So you're never alone. When you're a GACTL member, it's like you carry those 1,500 lawyers around with you in your pocket, just right there on your shoulder. So when you're representing a client and suddenly the hot light of attention shines on you and you're headed for cuffs and that steel door on the side of the courtroom, GACTL is standing by to swoop in, just like Ashley did, just like Alex Susor did, standing next to Ashley. And man, they got results. I mean,
Yes.
you've been reporting on it all last week and this week. The way that Ashley was able to come in there and just kind of put a stop to things, take judge to school and say, you know, actually, you don't know the difference between civil and criminal contempt. You don't know the difference between direct and indirect contempt. Let me tell you how this works. And then within 48 hours after that, we were getting the Georgia Supreme Court to step in and say, you will not put Brian Steele in jail. We're going to grant him a supersedious bond, going to give him an appeal. We're going to have a hearing. That's what GACTL strike force can do.
Yes, and it was amazing. Without that strike force, he would have gone to jail that evening, which was like a Wednesday or something like that.
You
And
see
it
him
was
take off his jacket? He took off his jacket. I just I wanted to see the S on his chest. It's just like, call me Mr. Steele.
right. Like, I love that. And I think Ashley gave an interview and she was saying that she was at her office and she got a call. She got the bat signal saying that Brian was getting he was hemmed up. And so she herself, she laid down her business at her office and went straight to court, walked in to defend him and did
And
such an
we're not
excellent job.
sending in somebody that doesn't know what they're doing. You're not going to get like an ADA Hilton who cries during the direct
Mm,
examination. You're going to get somebody that's got some real experience, that knows the law, and that is not afraid of these judges. You know, it's like, I want to say like twice this year already, I've had to stand up to judges and remind them that they are, what are they? A lawyer in a dress. Just because your desk is 12 inches higher than my desk doesn't mean that you can mistreat us or disregard the law.
absolutely. It's a crazy thing. So if Arturo, if you want to take 30 seconds to search the link that people need to donate whatever's in their heart to Gactyl, and then put that in the either in the private chat or the public chat. I will make sure to pin it to the top so these 11, 12, 13,000 people can do it. Can click on it, make it very easy for them. One of the things Gactyl does, guys, is it has a fund to help create new Brian Steeles, help create new Ashley Merchants, help create new Arturo Corsos. And Arturo, he probably has, more or less 10 years in the game on me. And he has taught me so much, and especially when it comes to criminal law, which I did not do. My focus was more on the family law side. Now I'm a big dog in the family law, but in terms of criminal, Arturo is the man. And so you guys can never really appreciate how much value you get learning from someone who is super skilled in their preferred practice area, especially if they have years on you in terms of experience and they've just seen so many things. And what Gacto does is train up, the mid 20-year olds and 26, 27, 28, 30-year olds and say, hey, let's create a new generation of Ashley Merchants, a new generation of Brian Steeles, a new generation of Arturo Corsos. It's so important. So please consider this. And guys, Gacto is at the forefront right now, pushing back against Judge Glanville. Who do you see pushing back at Judge Glanville? You see, number one, first and foremost, Brian Steele, who is an active member of Gacto. So Gactyl is being represented so strongly, but again, they're lawyers first and marketers second. And so you really don't see
I can't even
how
do it.
powerful. You can't even do it. See, that's what I was, what's that?
I put it in the private chat, and then when I try to put it in the regular chat, it said post failed.
Yeah, I think that's because that could be a YouTube thing. They don't really want you putting links there. So I'm glad you put it in the private chat. So I will put it in the public chat. And then AV, I sent you I emailed you the what are we talking about? The Kalis thing. If you want to review that, we are reviewing. And Arturo, Brian got ordered to be incarcerated because he would not release the name of Kayla Bumpkus, who was Little Woody's attorney, and Kayla has come out and filed a motion to quash and also a motion to recuse Judge Glanville because Judge Glanville specifically ordered her to show cause as to why
All right, y'all, we should be getting some action any minute now. It's what, 8 minutes to 1. We should be getting some action shortly.
All right, councils, where are we at this point?
Your Honor, we just received defense counsel's redactions. However, their redactions are in using an MP4 format. And so we need to convert it to evidence reviewer so we can know exactly what we're talking about. To answer the court's question, the state isn't ready at this juncture just because we just
Finally,
received it.
y'all,
So
we
we need to
back.
compare what they're asking for and see if it even lines up with what we gave them, because it appears that some may overlap. We just have not had the opportunity to sit down and compare our two lists. And so we would need time to do that. We would need time to do that.
Okay. How long are you gonna need to do that?
I'm not sure if the court was still leaving at 2, but we probably would need at least an hour, if not more, because again, they gave us about 13 periods of redactions.
Okay.
And so we need to play and see what time those are. So it's going to be a little tedious of a task to do. And some of them may correspond with what we gave them. We're just not sure at this time.
All right. Mr. Sharp, do you have something you wanted to add? Or Mr. Matthews? Yeah.
So, I believe Mr. Kokomo is copying the MP4 video for the state, so our timestamps make sense. Is that correct? Okay, so we're in the process of doing that, and we have to check behind using a different, what the format that the state was using. We have to go into that format to look at their redactions. So I think both sides are solid on what their own side's redactions are, and now we're entering the stage of checking the other side's redactions, proposed redactions.
Okay, all right. Mr. Matthews, anything? Did you stand? Okay, all right. All right, all right, well, you all can continue to work. I'll check back with you all at 2:10. And I have a unrelated meeting at 2:30, and we can see how much we can get done after that. All right?
Yes, sir. Thank you.
All right. So we're not going to be leaving today at 2, but we'll see what we can get done. And then that will also dictate whether or not I need to take some more time before we call for our jurors. Okay? Just depends on what we get done.
Yes, sir.
All right. Okay. Anything else? Okay. All right. All right. We're in recess until 2:10. So 2:10. I'll check with you all at that point in time. recordings from January 28th of 15 and February 21st.
So, Your Honor, I don't believe we've even started on the 21st yet. However, for January 28th, I have 6 more redactions to confirm, and I believe Mr. Shard says he has 9 more.
Good news and some okay news. The okay news is we're not quite done. We're on 11. We finished 11 out of the 17, reviewing 11 out of the 17 states' proposed redactions. I can say in the state, 1 we're okay with, 2 we're okay with, 3 we're okay with, 4 we disagree and we're okay with, except we believe 722.35 to 724.01 should stay in. 5 we agree with, 6 we agree with, 7 we agree with, 8 we agree with, 9 we disagree with, 10 we generally agree with, except we believe 751.19 to 751.22 should stay in. And we can talk about that. 11 we disagree with. So that's where we're at. So we do have a fair amount of agreement.
Okay. All right. I have an unrelated matter to take up in a few minutes, and I'll check on you all probably around 3 o'clock. Okay.
Yes, Your
All
Honor.
right. So continue to work. I see that. All right.
I think we might be getting some action. Hold on, let's see.